Hey, everybody. Welcome to In Broad Daylight, a solo podcast hosted by me. Who am I? I'm Adam Todd Brown. Thanks for showing up here today. I straight up love you. Smooth segue alert. You know who I don't love? The United States Supreme Court. If you've been following the news at all, you know the Supreme Court has been up to some shenanigans lately. The hot story right now is the recent ruling that the president has total immunity from prosecution when it comes to official acts carried out as president. Somehow, that is actually one of the tamer of the Supreme Court's recent rulings. And we'll talk about why that is a lot more later. But first, let's talk about some of the other recent Supreme Court decisions that should worry and or anger you a whole bunch. Like how the Supreme Court recently ruled that the Sackler family can still be held liable for literally causing the opioid epidemic in this country. This is an excellent example of how, whenever you see a headline that makes it seem like the Supreme Court did something great or even just good, make sure you read the article first before you go post on Twitter, currently known as X, about how sometimes the bad guys get it right. Because you see, the issue that was before the Supreme Court was the bankruptcy settlement the Sackler family negotiated after all hell broke loose for them legally. The deal called for Purdue Pharma to direct $6 billion in funds toward fighting opioid addiction, with 750 million of that going to victims and their families. The claimants would have received anywhere from $3,500 to $48,000 each. But part of that settlement stipulated that the Sackler family itself could not be held liable for what happened, even if the company they did it all through could be. The Supreme Court objected to that part and, as a result, shot down the entire bankruptcy settlement. So, again, the part where they decided the Sacklers can be held personally liable sounds like a real hell yeah moment in American history. Problem is, that settlement agreement was negotiated with and overwhelmingly agreed to by some 60,000 individuals, along with 2,000 governments. How are there even that many governments? Of those numbers, 95% approved this agreement. During oral arguments, Justice Elena Kagan, an Obama appointee, if you're keeping score at home, said this about the settlement. It's overwhelming, the support for this deal. And among people who have no love for the Sacklers, among people who think that the Sacklers are pretty much the worst people on earth, they've negotiated a deal which they think is the best that they can get. Or, another way to put it, the Supreme Court, by rejecting this bankruptcy settlement, ruled in favor of the justice we want, not the justice the actual victims wanted. Also, if those potential settlement amounts I mentioned earlier sound kind of small, given the stakes of the crime, you're right, which is exactly why the settlement probably should have just been approved. If you don't believe me, and why would you? I'm not a lawyer. Here's a quote from Ronald Mann, a Columbia Law School professor who specializes in bankruptcy litigation, talking to Rolling Stone magazine. It's very difficult to overturn this plan because to overturn this plan is really to take $6 billion out of the hands of people that are really, really badly injured. It's money that they will most likely never get if they do get it. Lawyers will make huge amounts of money recovering this, so it may just be a windfall for lawyers to litigate for years. End quote. So lawyers will get rich, and me and you get to take to social media and tell the Sacklers not to drop the soap in prison. And the people most directly impacted by this still have to wait a little bit longer to get justice of any sort, if they ever get it at all. But hey, even if a person has some complaints about the Sackler family decision, surely there is no fault to be found in the recent ruling that says, Second Amendment be damned, domestic abusers cannot own guns. Well, I mean, that just sounds as right as rain, huh? Except not really. Don't get me wrong, convicted domestic abusers absolutely should not be allowed to own guns. I totally agree with that part. Except, as pointed out by Ellie Mistal, writing for The Nation, the magazine, not like all of us collectively, a lot of media types are using this as proof that our conservative controlled Supreme Court is, at the end of the day, actually pretty moderate. But no, this isn't about victims of domestic abuse. This is, against all odds, about making sure our current gun situation stays almost exactly as bad as it is right now forever. You see, in another recent case, New York State Rifle and Pistol Association versus Bruin, which will just be called Bruin from here on out, like they do on TV, in what I would argue is one of the most insane Supreme Court decisions in recent history. The conservative majority ruled that for a gun law to be constitutional in the 21st century, that law had to already kind of be in existence when the Second Amendment was ratified in the 18th century. You heard that right. The 18th century, back when you could still own a guy. If the gun law in question doesn't have a historical analog dating back to that totally chill and normal point in American history, then you can't enforce it today. That is the actual guidance the Supreme Court is using these days when it comes to gun laws. Is it a law that was on the books hundreds of years ago? If not, sorry, it can't be on the books now. Or, to quote that Nation article, if a government wants to pass a gun regulation, it either has to find a historically analogous gun law drawn from 1791 or earlier, or we die. And hey, if that's the case, why are we even making new laws for anything? All we need is in the Constitution. Repeal all laws, fire the judges, abolish the Congress, defund the police, no more president. Like four of those five things would actually be fine, and kind of the fifth also. And see, this case should have been a slam dunk challenge to that absurd notion, because domestic abuse seems like it's still barely a crime in 2024. You probably got money from the state for doing it in 1791. Nice try, libs. Our conservative Supreme Court was ready for this maneuver and argued in their opinion that the Constitution has always, quote, included provisions preventing individuals who threaten physical harm to others from misusing firearms, end quote. And okay, but is that a direct historical analog? Did the sexist, racist slave owners who founded this country and framed our Constitution consider domestic abusers a threat to others? It's 2024, so I'll take the customary pause here to reassure people that I am not arguing for domestic abusers' rights to own guns. I'm arguing against the idea that a gun law has to have existed in 1791 in order for it to be relevant in 2024. With this domestic violence ruling, the Supreme Court is basically changing the Bruin ruling to mean that there needs to be a historical analog, but it doesn't have to be an exact twin. Or to put it in layman's terms, fuck you, we do what we want. This one was a layup because the public outcry, if it went the other way, would have been intense. But now it just seems like a PR victory for the Supreme Court. And even better, they get to pretend like the Bruin ruling is actually a thing that makes sense in the real world, when it obviously is not. Meanwhile, as I discussed on a recent episode of Conspiracy the Show, plug, get it wherever the podcasts are at, the Hunter Biden legal team had eyes on this case, because if denying a domestic abuser the right to own a gun was ruled unconstitutional, then surely owning a gun as a selfie-taking crack smoker deserves the same protection. And imagine being Hunter Biden's legal team and thinking this Supreme Court was going to come through on your behalf. That is dumb. I have no doubt that when it comes down to it, This Supreme Court will find a reason to claim crack existed in the 1790s. Founding fathers hated it. To prison you go, Hunter Biden. That part's fine. And see, this is one of the problems with this current incarnation of the Supreme Court. They seem to have a real knack for issuing rulings that are either bad when they sound good or hugely important when they seem like bullshit you have no reason to care about. And that gets confusing. A good example of the latter is their recent ruling in SEC versus Jarkesy. In that case, they ruled that a defendant in a case brought by the SEC deserved a jury trial instead of having their case handled by an administrative law judge. On top of seeming like a thing most of us would never have any interest in knowing about, this one is also insanely hard to understand. As far as how important the ruling was, this is the title of a Vox article about it. The Supreme Court just lit a match and tossed it into dozens of federal agencies. Well, that sounds bad, and it sure is. And Vox writer Ian Millhiser does his level best to explain why. And I will link to that article. But I had to go read the text of Sonia Sotomayor's dissent to actually understand it, which feels like the opposite of how that should work, but it's fine. I'll link to that also. Anyway, you know that thing where employers can and often do make employees sign a thing saying that if a legal dispute breaks out, you agree to handle it with an independent arbitrator instead of suing them and letting the courts decide? I agree that it's a bad thing when it comes to your boss, but the government has a similar rule in place, and it's meant to streamline the process for punishing people who violate government regulations, like employers who violate OSHA safety regulations. If that helps make it hit home a little more, that's the government agency that holds your employer accountable if you get hurt at your job because of your shitty workplace conditions, among other things. When it comes to the government, their version of a third party arbitrator is called an administrative law judge. For a long, long, long time, several government agencies operated on the precedent that when it comes to going after rule breakers, they were good to bypass a jury trial and go through an administrative law judge instead in instances like this. Important note, we're talking about civil suits here, not criminal. Very important distinction. There are lots and lots of laws on the books that were enacted by Congress on the premise that they'd be dealt with by an administrative law judge, because that was the legal precedent everyone was working with for decades and decades. In the case of some government agencies, like the SEC, in this case, the option exists to go after offenders in criminal court. So that's fine. They still have a course of action they can pursue to get justice. Problem is, with a lot of government departments, including the aforementioned OSHA, along with other agencies that right wingers typically love, like the Federal Energy Regulatory Commission, Federal Mine Safety and Health Review, the Department of Agriculture, the list goes on and on. Those groups are only allowed to go after those who violate their regulations through an administrative law judge. Meanwhile, the Supreme Court has now ruled that if the defendant requests it, they get a jury trial in front of a for real court. But they issued that ruling without addressing how government agencies that are only allowed to use the administrative process are supposed to punish those people who ignore the various laws and regulations of the land. So now a bunch of government agencies that do actual good are kind of sort of legally forbidden from enforcing that good for now. What happens if they try to punish someone and that someone requests a jury trial? Are they even allowed to carry on from there by law? Again, Supreme Court hasn't addressed that part yet and probably won't for years. Until they do, at least for the next few terrifying years, corporate America kind of gets to do whatever they want while the regulatory agencies of the world just look on helplessly, wishing they could impose even the minorest of civil penalties. At least I think that is truly what is going on here. Read the article for yourself and tell me if I'm wrong in the comments, I guess. I won't reply, but tell me anyway, baby. I'll give it a heart or something. What really irks me here is the ignoring of precedent. That is the terrifying part. I mentioned earlier that government agencies and the courts both have been following this precedent that some things are dealt with by way of administrative processes instead of courts for decades. What makes this ruling, in my opinion, secretly the most terrifying of any of the court's recent work is this bit from Justice Sotomayor's dissent. Quote, a faithful and straightforward application of this court's longstanding precedent should have resolved this case. Faithful adherence to precedent is a foundation stone of the rule of law. It allows courts to function and be perceived as courts and not as political entities. It promotes the even handed, predictable, and consistent development of legal principles, fosters reliance on judicial decisions, and contributes to the actual and perceived integrity of the judicial process. This ruling is the Supreme Court signaling loud and clear that precedent doesn't matter anymore. The conservatives have the majority, and they will use that majority in whatever way they see fit. That is scarier than any presidential immunity ruling could ever be. That is size 10 chaos, is what that is. Buckle up, America. Things like this usually end a certain way. And so now let's talk about that presidential immunity ruling the Supreme Court just handed down. As is so very often the case these days, the thing everyone is pointing at the most and yelling the loudest about isn't really the thing we should be the most worried about. The talking point that's spreading like the proverbial wildfire right now is that the Supreme Court just ruled that the president can have SEAL Team 6 assassinate a political rival and face no punishment at all. And please take comfort in knowing that is only sort of the case. For one thing, if it was that cut and dry, I think we all know what the Biden administration would be working on right now. And I don't mean trying to convince us Joe Biden is still the man he was when he heroically served his country by taking out corn pop at the public swimming pool back in the day. To get an idea of how limited this immunity ruling actually is, please consider that the hush money trial is still going. Sure, this ruling might get Trump's charges dropped in that case, but only if his legal team can convince a judge that clearly is not on their side that paying hush money to Stormy Daniels was an official act. Just like Dante's version of hell, there are layers to this ruling. On the one hand, the court did rule that the president has absolute immunity for actions that fall within the quote exclusive sphere of constitutional authority. That is the delicious top layer. After that, the ruling says the president has quote presumptive immunity for other official acts, which I assume means stuff like toppling foreign governments in bloody coups and whatnot, basic presidential busy work. For private or unofficial acts, there is no immunity. That's why this ruling probably won't move the needle much in Trump's direction in the Stormy Daniels case. But the case special counsel Jack Smith is building over the January 6th insurrection, that's probably doomed. And that's probably what this ruling is really about. This is all explained better than I can explain it in an opinion article published on The Hill, written by attorney and political analyst Jonathan Turley. I'll link to it. The reason everyone thinks this means the president can order the military to kill a rival in the name of national security is because, Justice Sonia Sotomayor said that in her dissenting opinion. Here's a quote. The president of the United States is the most powerful person in the country, and possibly the world. When he uses his official powers in any way, under the majority's reasoning, he will now be insulated from criminal prosecution. Orders Navy SEAL Team 6 to assassinate a political rival? Immune. Organizes a military coup to hold on to power? Immune. Takes a bribe in exchange for a pardon? Immune. 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 The actual ruling does address bribery and how a president could still be prosecuted for that. And somewhat comfortingly, also pointed to Trump's plan to steal the election by drawing up a slate of fake electors as a thing that wouldn't meet the standards for immunity. Once again, don't get me wrong, this ruling sucks, like pretty much everything else the Supreme Court is doing these days. But this one also feels like more of a distraction than anything else. Because just consider what we're talking about here: presidential immunity from prosecution for their actions in office. So, you mean as opposed to all of those presidents before this who faced all sorts of legal consequences from their actions in office? While I do think this Jonathan Turley article makes some strong points, I also find it completely fucking laughable when he points out that even if a president did try to have a rival assassinated, the military would refuse to follow an illegal order of that nature. Yeah, like when Obama and our current savior of democracy drone striked an American citizen. Did they have a gamer do that? Or was it the military? Who did George W. Bush send to war crime the ever loving shit out of the Middle East after 9/11? Was it the Wagner Group? Because that wouldn't have surprised me one bit. But no, it was the American military, and almost only the American military, if you remember that part. Who did Reagan rely on to burn down villages whenever communism reared its ugly child feeding head in Latin America? Okay, well, that was the CIA and rebel groups they trained and armed with all the money they made selling crack on the streets of Los Angeles. That was a bad example, but you get what I'm saying. I could go on and on with the examples. I don't care that the Supreme Court issued a ruling that expands presidential immunity because the president is already immune from everything. Well, hush money trials and the obvious effects of aging aside. Everything else, though, fucking do it, dude. You're the president. That's the only real law in this country. And hey, that's the episode. Thank you so much for listening or watching or both. Please subscribe and like and do all that stuff. And thanks. We love you.